work to counter racial division and build more just society through research, policy solutions, and thought-provoking conversations like these that hopefully address some of the more contentious racial issues in American society. So, Brionna and Dayle, wonderful, fantastic two of us at the law school, have been working with us this year. Brionna's going to share a bit about a really complex area of law today, where she's going to talk about the ability for the president to, the questionable ability for the president to deploy National Guard troops in American cities to support with immigration enforcement. And then Dayle is also going to talk about another complex area of law related to the California Racial Justice Act, particularly regarding the types of evidence that a litigant can bring to show racial discrimination in their criminal legal process. So before we get going with the presentation, I am honored to introduce Luke Bliss, who's the pro bono partner at Sonsini. He is also an SCRJ alum, so welcome back, Luke. And a dear friend of the center, a legend in his own right, always, fantastic individual I've gotten a chance to get to know over the last few years. And he's going to talk a bit about Harry Bremond, who is the trailblazing attorney that we named this fellowship after, and we'll also talk a bit about the partnership between the Center for Justice and Wilson. Yeah.
Well, Wayne is too kind as always. He's so nice to me because we're both also Oregon Ducks for our undergrad studies, so we have that in common. So I want to just thank all of you for being here today, and I just want to say a little bit about our dear friend Harry Bremond, who is the inspiration of this award, that handsome gentleman in gray right there. That was last fall over at Sonsini, just down the street. Harry was born in 1934 in Texas. He grew up in the projects of Texas and then in San Francisco. He was one of the first black graduates of USF Law School. And at the time, he could not get hired anywhere. No one would hire him as a lawyer. He ultimately came down to San Jose and worked in a cannery, not in the legal department, but just in the cannery. But I think one of the things when I think about Harry, it reminds me a lot of Silicon Valley itself, right? This is the engine of innovation in the world. And Harry himself was an engine of creating opportunity for himself and opportunity for others. And he did that through exercising relentless optimism. So he didn't take those early no's as an opportunity to give up or curl up into a ball or say, I'm not good enough, I am what these people say, I am these people who diminish me. He persevered. He ultimately joined Wilson Sonsini, the firm that I'm a partner at today and run our pro bono program, in 1967, when that was unheard of. There was 5 or 6 lawyers at the time. He was a partner for decades. He founded our pro bono program, super active in civil rights, racial justice, and pro bono throughout his career, while also being a very trusted advisor to some of the biggest name companies that you'll ever hear of. All throughout that, the thing that stands out most about Harry is his character and his caring for others. He was always a mentor. He always was looking to pay it forward. He always was giving of his time and energy, and as Rick knows well, speaking the truth with love. Quang mentioned I was a Stanford alum as well. I graduated in 2006. This looks very familiar to me, except I would have never been on a class on a Thursday night. That said, I'll never forget when Harry showed up to graduation, pointed at me, and I thought he was going to just shower me with compliments for being so brilliant to finish law school and go out to the law firm. No, it was, Luke, get your ass in the library and study for that bar, because I'm going to kick your ass if you don't pass it. I repeated that about 3 times, and I believed him, and so I got in the library and passed that bar. And then we went on to become great friends. He continued to be a mentor to me and so many others. Lived a wonderful, purpose-filled life, and ultimately passed away this last December at the age of 91 after just a beautiful, wonderful run of humanity and an inspiration for what we can all strive to be. And I think what Harry would say about this moment, and he's so proud of Dayle and Brionna and this fellowship, and what a blessing that we were able to share it with him while he was still able to be here to enjoy it. And I think he's so proud of that and interested in the work that you all are doing. And I think it's an inspiration to think of that and to think of his message, and it will continually go on in both Dayle's work and Brionna's work, as well as future Harry Bremond fellows. So with that, I'll turn it over.
opportunity to happen for students at the law school. It's been so meaningful for us, and I'd be remiss if I didn't acknowledge Dayle Chung, who's here, who was integral in that development of this partnership. So thank you so much. Dayle, can you just raise your hand? Brionna is up. Brionna, take us away. And once Brianna's done, we'll have Q&A with the audience, and we'll switch over to you. Let's give Brionna a warm welcome.
Well, thank you very much, Wang, and also Luke for the introduction, and thank you all so much for being here. My name is Brionna. I'm a 2L here at the law school, and I'm just really excited to share a little bit more about the research that I've been developing about federal use of the National Guard to support immigration enforcement. So to start with some background and my entry into this work, I want to take us back to early 2025 when the Trump administration began its violent immigration crackdown. Now, I want to do a kind of a show of hands here, whether it was on the news or through social media or in some other way. How many of you heard about this activity in any way? Yeah, thank you. So it seems like nearly all of us. I won't ask you to share if you were personally impacted by the immigration raids, but I can presume that many of us in this room, myself included, have felt closely tied to this issue. This immigration policy saw the use of firearms, tasers, and chemical agents in neighborhoods. We saw the deliberate targeting of day laborers and vulnerable locations with ICE waiting outside of daycares and Home Depots and also immigration courts to detain migrants. In many instances, this violence was occurring even after being ordered to stop, and migrants were not the only casualties. US citizens were also assaulted, detained, sometimes held without communication and unbeknownst to their families for days before being released. And these recounts are just a few of the many violent encounters that citizens and non-citizens alike faced with federal agents in a systematic pattern of violence as part of the Trump administration's aggressive immigration crackdown. And as these immigration raids swept across cities, they were met with pretty firm resistance. People swiftly took to the streets to express their disapproval of the way, as Angelica Salas describes it, their community was being attacked and terrorized. We saw this first in Los Angeles, and then in Chicago, and in Portland, and in other cities across the country. And in response to these protests, the president called into service the state National Guard to temporarily protect ICE from, quote, violent protests that, quote, directly inhibit the execution of immigration law. And again, this happened first in California, and then in Illinois, and then lastly in Oregon. And each of these states subsequently sued the administration, arguing ultra vires, commandeering, and separation of powers claims. And in the cases of California and Oregon, the Ninth Circuit stayed the lower court injunctions, finding that the president's assertions were likely sufficient to establish an inability to enforce federal law. The Seventh Circuit acknowledged this deferential standard in the Chicago case, but ultimately upheld the lower court's injunction, finding that the facts do not justify the president's actions in Illinois under Section 12406, even giving substantial deference to his determination. I think that the significance of these events can't be understated. So first, Trump federalized the National Guard under 10 U.S.C. Section 12406. I want to do another hand raise here. How many of you have ever heard of the Insurrection Act? Okay, actually most people in this room, okay? Now, how many of you before last summer had ever heard of 10 U.S.C. Section 12406? I think that's to be expected. It doesn't really have quite as nice a ring to it, but also it was only codified in 1956. It's only twice been invoked before, and it's never been used as a standalone authority. So Trump's use of the statute raises many new doctrinal questions, some of which the court is currently grappling with, and some of which I try to tackle in my research today. Second, the president sent military forces into a domestic conflict, which contravenes the United States' long history against domestic military intervention. And lastly, the president's use of domestic force to quell immigration protests materialized in a distinctly racial context and contributes to a policy that reproduces a hierarchy by physically and also symbolically suppressing the valid exercise of citizenship by protesters. In the ongoing litigation, the government asserts that the president is the sole judge of determining whether to invoke Section 12406, and that decision, on whatever basis or on no basis at all, is completely immune from judicial review. The Ninth and Seventh Circuits at least agree that the issue is not a political question, but the appropriate deference and the standard of review of the president's determinations under the statute are amongst several splits in the circuit opinions. And when the issue made its way to the Supreme Court on the emergency docket, the court didn't answer the question. And so my research takes up the question that the court deliberately left open, which is whether a president's decision to federalize the National Guard under Section 12406 is justiciable and the applicable standard of review. Central to my argument is that it's vital to recognize the distinctly domestic context of the Section 12406 authority. So it concerns the use of state militias to settle domestic disturbances, which is pretty obviously domestic, but I think that there's something particularly domestic about the provision that Trump relies on in these cases, which concerns an inability to execute federal law upon U.S. residents on U.S. soil. The American tradition has a really long history against domestic military intervention, deriving both from British precedents and also the experiences of the American Revolution. And at the same time, the framers also recognized the necessity of having a federal power to respond to domestic crises. And the result of these objectives was a very carefully thought out compromise known as the Calling Forth Clause, which attempted to balance the pervasive and potentially catastrophic threat of a standing army with the need for a strong and centralized mechanism for responding to internal crises. It gave Congress the power to provide for the calling forth of the militia to execute the laws of the Union, suppress insurrections, and repel invasions. And Section 12406 is an effectuation of the Calling Forth Clause. So to the extent that this provision, or this clause, limits Congress's power to call forth the militia, it also circumscribes the president's delegated statutory authority to federalize the National Guard. I think that there are three concerns from the constitutional debates that are reflected in this careful compromise. First, there was concern that even these limited exceptions maybe were too broad and that the power might be abused to regularly call forth the militia. But the framers explained this away as a power of last resort. The civil power was always meant to be the first response in a domestic disturbance. And Congress could only call forth the militia when it was absolutely necessary. And by absolutely necessary, the framers meant where the civil power was insufficient to quell the dispute. The constitutional debates also underscore the fear of granting substantial control to the president specifically, because it would elevate him to a status like the British monarch. And too much power would allow an unchecked ability to turn the military against the people, which was a serious threat to civil liberties. And as a result, the framers very carefully allocated the militia authority between the federal government and the states, with states retaining primary control of their militias. And the Constitution further divided the federal militia power between Congress and the president, granting the legislature the exclusive authority to call forth the militia, while making the executive the commander-in-chief of the militia only when called into federal service. The Constitution ultimately gave the federal government the same powers to use military force in a domestic disturbance that state governments had for long exercised. But there's always little doubt that this was a concurrent power and it was shared with the states. And unlike foreign affairs, where the president has a unique intelligence advantage and diplomatic expertise, domestic affairs actually advantage state governors who possess the most intimate knowledge and skills to track frontline developments. States thus have a sovereign interest in controlling their militia. And by federalizing the militia, the president essentially challenges the state's own assessment of the civilian arms capacity to resolve the disturbance. Naturally, then, the governor could resist a calling out of her state's guard if she disagrees with the president's determinations. And as arbiters of such disputes, courts have an important role to play in protecting state sovereignty. And this gatekeeping role is recognized in many important ways by the statutory language itself. So this is Section 12406, and as a reminder, Trump used the third provision in the ongoing litigation and asserted that his determination is a political question. But nothing in the plain language makes the president's invocation unreviewable. In fact, the statute enumerates express predicates that must exist before the executive may act. thus circumscribing his power by placing a reviewable limit on his discretion to invoke the authority. The operative word whenever functions as a statutory gatekeeping condition. In other words, Congress did not authorize the president to federalize the guard whenever he so chooses, but only when a particular enumerated scenario arises. And the text further demonstrates Congress's ability to grant explicit discretionary judgment when it so chooses. It authorizes the president to call forth guard units, quote, in such numbers as he considers necessary to respond to the qualifying circumstance. I'm sure that you have all heard of the chicken and the egg question, which one came first? This is a little bit like that. So for a president to exercise his discretion, there must, in the first instance, be an invasion, a rebellion, or an inability to execute the laws. So Congress thus distinguished between two distinct questions: the threshold question of whether a condition exists, and the discretionary question of how many personnel are needed to respond. Congress has, in other statutes like the Insurrection Act, actually explicitly confided both of those determinations to the president's discretion, but noticeably did not do so here. And I think it's also important to point out that the statute seemingly recognizes the role of states by requiring orders be issued through the governors of states. Congressional hearings reveal very little about Congress's intent. However, the use of troops in civil disturbances is a practice that dates back all the way to the Militia Act of 1792, which was circumscribed in many important ways. First, the civil authorities must be tried and exhausted before the federal government could intervene. And before having the militia execute the laws, the president must either be requested by the states or receive judicial permission by proving the civil inability. Although the renewed 1795 Act removed the judicial pre-authorization requirement, it continued to limit the president's authority to the extremely rare condition that neither the federal marshals nor the ordinary course of judicial proceedings could execute the laws. And Congress actually later tested and then rejected expanding the president's militia power discretion during the Civil War by amending the act to allow the president to call forth the militia, quote, whenever it shall become impracticable in the judgment of the President of the United States to enforce federal law. But Congress completely excised this deferential language in the massive legislative overhaul of the Dick Militia Act of 1903. And they also substituted impracticable for the higher bar of unable, and this is the same language that we see used in the statute today. And the 1908 Militia Act made two important amendments. First, it authorized the president to call forth the guard outside of the United States for the very first time. And second, Congress replaced other forces with regular forces and added that orders must be issued through the governors of the states. These changes bifurcate executive authority, one in which the president deploys the militia overseas in a foreign dispute, and another in the distinctly domestic context, where the president, in consultation with states, federalizes the militia to execute federal law. Although the Ninth and Seventh Circuits took a highly deferential standard of review as a foregone conclusion, I think that this history reveals that every militia delegation authorizing federal intervention in domestic disputes has carefully restrained the president's power to use the militia in domestic conflict. I want to shift briefly now to thinking not only about why we don't have to grant extreme deference, but why we might also not want to. I asked you all in the beginning of this presentation to think about public safety and what it means to you and who it's meant to protect. I think this is a question that I hope that you all continue to interrogate after you leave this presentation. For me, when I think of public safety, I think about the way that people of color have historically been painted as aggressors and often been excluded from what we typically consider, public safety resources, even when they ask for them. And in the course of my research, it became clear to me the role that race plays in an exigent power like Section 12406. And we can see that in the Trump administration's use of highly racialized rhetoric to create an exigency in the name of public safety where none existed. So in Los Angeles, despite Governor Newsom affirming that local police were handling and maintaining the scattered protests, the president declared that Los Angeles was being, quote, invaded and occupied by illegal aliens and criminals, and directed his officials to take any action necessary to, quote, liberate Los Angeles from the migrant invasion. Similar language was used when invoking Section 12406 in, quote, war-ravaged Portland and Chicago, where the government was actually later judicially determined to have submitted multiple inconsistent statements and blatant falsehoods to justify the federalization. So I think that this kind of goes to show that race is functioning to manufacture a crisis, and I think it's really important to recognize who is being saved here and who the government is trying to save them from. Under the Ninth Circuit's highly deferential standard, the court refused to consider this evidence or to appropriately weigh the state's own assessment of the civil capacity. A lesser standard of review thus risks allowing a president to produce an inability to enforce the laws as a pretext for domestic occupation. And in today's context, less judicial scrutiny disproportionately impacts immigrants and other communities of color. If the president can invoke an exigency on a purely subjective basis or on no basis at all, the carefully circumscribed limitations of the statute disappear. A more searching judicial inquiry is the essential constitutional safeguard that refuses to let the president turn the National Guard into a domestic weapon against his own diverse citizenry. It's required to ensure that 10 U.S.C. Section 12406 remains a tool of genuine emergency rather than a pretextual mechanism for the racialized militarization of domestic cities, of American cities. And as the issue continues to percolate, courts must strongly consider the role of states, the fact-finding advantage, and the court's own part in protecting the foundational principles of sovereignty and federalism which pervade the American tradition. Thank you.
We will take Q&A for Brionna. If you have questions or feedback?
So one question I have is, like, more recently, have you seen any, and it's hard to like discern a lot of like meaning from a lot of things, but have you seen any shift in strategy in terms of, it doesn't seem that the Trump administration is trying the strategy, the same strategy as much. Have you seen that evolve in recent months?
It's been really interesting. I always say one of the most challenging parts of this specific research was actually the fact that this was such a live issue. So I started my research before the issue came onto the Supreme Court shadow docket. And so the shadow docket opinion came down in December, and it was really interesting to see the way that the Trump administration pivoted after that, that ruling. So they ended up, they dropped the appeal in the Oregon case. The California case had already finished, but they were considering appeals to the Supreme Court. And it's interesting because I've talked to some of the other students who are actually doing work on this at the center, and I think that there was certainly a world where the administration could have taken it back up to the Supreme Court again, and definitely could have gotten a more favorable ruling. But I think that the court's hesitancy to rule definitively on any of these issues the first time around was less an approval of the administration's actions and more so a result of the fact that I think that a lot of the court couldn't agree. And so I think the Trump administration also recognized that and had to be a little strategic in what they decided to bring back up to the court a second time.
Yeah. And an observation, I thought this was excellent too. And it is amazing how real time it all is. And then it is like, there's legal analysis, and then you can think about over time too, just how opinion has shifted just based on events on the ground. So I think like a year plus ago, people were terrified. I know law firms were doing a lot, like things. And when I look at it now, it's completely different. And I think that has impacted them. And I think that shows the power of people having their voices heard and being out there as well. And I think, so I hope people, even in very dark times, are encouraged by that.
Yeah.
No, thank you for this. It could not be more timely, obviously, and very
This is one of the issues that it was raised in some of the litigation. None of the circuit courts actually ruled definitively on this. There's been arguments made that the part of the statute that says that orders must be issued through the governors of the states, obviously the states are arguing that means you have to consult with the states. You have to go to the governor and in consultation decide. And then the Trump administration obviously was arguing, we just have to tell you guys. And in fact, that's kind of that was one of the major issues in the California case specifically, because the Trump administration sent it directly to I forget what the name of the position is, but the people who the guy who controls the National Guard, him, just sent the order directly to him, not to Newsom, and put on the top of the paper issued through Governor Newsom, even though it came from the president. So they're like, that's us checking the box, it's issued through the governor. So I think that is one of the questions up for debate. I think my interpretation is not necessarily that that they have to be in consultation in the sense that they need to debate back and forth and decide. I do think that the statute and the history suggests that that states are involved in that decision, and that to the extent that the president's concerned, perhaps that a dispute might not be maintained, that's something that would then go to the governor to say, is it being maintained? How many civilian, the civilian arm, how are they maintaining this? The local police, how many numbers that you have, to actually get a sense of the situation.
And if they can't come to terms, though, I know this is like the
yeah.
Right? If they can't come to terms, in your view, right, does the governor get a veto over the presidential policy or no?
I don't think so, but I think that's the role of the courts. I think that's the other thing I'm trying to emphasize, is that I think the courts have tried to take the view that maybe they shouldn't be involved in this at all. And I think that courts actually play a very important role here, where when there is a dispute that the states and the president can't come to an agreement, that the courts have to step in. That's part of their role here, is to arbitrate.
Yes. No, we can go both.
This is great, thank you. It's super interesting. I didn't know a lot of it. You mentioned kind of the need for a more exacting standard of review, or a more searching standard of review. Do you have a perspective on how you kind of articulate what that looks like? Is it possible to analogize it to a standard of review we might have heard about in our law school classrooms?
So that's actually the part of my research I'm currently working on. So I don't have the exact standard of review just yet. I think I'm really leaning on the statutory language here. So, for example, I mentioned that some of the statutes are the use of the word unable, unable to enforce federal law. There's been a lot of debate about what that word means, how much inability equals unable. And the Ninth Circuit said, well, a little bit of impediment isn't unable, but basically anything else probably is. And I think that, as we can see, I think that's actually a higher standard than what the Ninth Circuit said that it was, based on the history, kind of the legislative development of that word. I also think there's been a lot of arguments made about the literal definition of to be unable means to have no capacity to respond. So I think those are areas where I'm trying to develop kind of what a higher standard of review would look like, but I don't have a exacting yet.
Sane person.
Yeah.
That actually kind of addressed it, but it was going to be about the relationship between the inability to control or enforce the laws and the amount of discretion that the president has to act, basically.
Yeah, under the standard that the Ninth Circuit, and to some degree also the Seventh Circuit has set, it's extremely deferential. But I think I'm arguing that inability means inability, and part of that inability calculus means how able is the civilian and the civilian police to address the dispute.
Wonderful.
Thank you so much. struggling. This is weird. Okay. Let's time myself. Hi everyone, my name is Dayle and I'll be talking about the California Racial Justice Act and specifically proving racial discrimination in criminal sentencing. So, I don't know how familiar you all are, but the California Racial Justice Act was enacted in 2020 and it has a pretty lofty goal, which is to eliminate racial bias from California's criminal justice system. And it aimed to address centuries of historical and embedded racial injustice that have been at play in the criminal legal system. So what does the statute say? It says that the state shall not seek or obtain a criminal conviction or seek, obtain, or impose a sentence on the basis of race, ethnicity, or national origin. And this allows an individual to challenge racial discrimination in all types of crimes at all stages, including policing, charging, conviction, and sentencing. And also, individuals can prove race, ethnicity, and national origin discrimination, so not specifically limited to race. This is not the first Racial Justice Act. North Carolina also passed a similar statute, but different in a number of respects, in 2009, which is far more limited in that individuals can only challenge death sentences, and they can be brought in post-conviction motions after they're sentenced to death. There were a number of successes under this statute. This is Marcus Robinson. He was actually the first person to bring a petition under the North Carolina Racial Justice Act, or the RJA, and this is his family after his death sentence was overturned. Unfortunately, the statute was repealed in 2013, but there's a 2020 North Carolina Supreme Court decision that says that people who filed their petitions before the repeal can still bring their claims to court, so that's still ongoing today. So both of the RJAs were in response to this Supreme Court case called McCleskey versus Kemp. And Warren McCleskey in 1978 was convicted of armed robbery and murder. And he was sentenced to death, and in order to challenge his sentence, he brought forward the statistical study, which shows, among other things, that defendants charged with killing white victims were 4.3 times as likely to receive a death sentence as defendants charged with killing black victims. And he was a black man convicted of killing a white victim. So the Supreme Court rejected this study. They made this somewhat shocking statement that apparent disparities are an inevitable part of our criminal justice system, and that they rejected his equal protection claim because they said there was no evidence that decision makers in Warren McCleskey's case had acted with discriminatory purpose, and there was no evidence specific to his case. So the California legislature was not happy with that and thought that disparities in the criminal legal system should not be inevitable. So I asked you all, I don't know how many of you saw the question, but I asked you all to think about kind of times at which racial discrimination can occur in the criminal legal system, or kind of examples of when it can come up. I opened the floor. Does anyone want to share any instances that could come up?
At the inception, or at any point. But
Right.
Definitely at the inception of even a stop.
Right, exactly, like police stops. Yeah. Any other ideas?
A judge handing down a certain type of sentence for a particular race that
Yeah.
may be worse than for another race.
Yes, exactly. So both of those can be addressed under the statute, and I would say the police stop, that Luke example you brought up, that would fall under a case-specific claim. So there are two types of claims that you can bring under the RJA. One is a case-specific claim where there's someone who acted in the defendant's particular case and they exhibited racial bias or animus. So law enforcement officer is one of those. So if there's racial discrimination in how the law enforcement officer conducted their stop or other policing, that can be challenged. And also sentencing, that can be something, if there's a particular sentence that is biased or animus in a particular case, that can be challenged. The other category of claims are county-wide pattern of disparity claims. So this is kind of similar to McCleskey's case, in which maybe you can't show that there was someone who said something racist or did something racially motivated in your particular case, but there are county-wide disparities in how you're sentenced or how you're treated
And the countywide pattern of disparity claims kind of allow individuals to bring those types of claims if they can't prove individual discrimination in their case. So there are two types of pattern of disparity claims. Pattern of disparity is actually a term that 3 scholars who are working in this field came up with. But A3 focuses on charging or conviction, but I decided to focus on A4 because, surprisingly, although there have been sentences overturned under the California Racial Justice Act, there haven't been sentences overturned under the A4 provision, which has to do with countywide disparities. And none of the literature, most of the literature and the court decisions kind of focused on the A3 claims, and this is where most of the activity has been. So I kind of wanted to focus on the A4 claim where there hasn't been as much discussion. So for all types of claims, there are 3 burdens of proof, and the more you prove, the more that you get. So under good cause, that's the lowest standard, and a petitioner or defendant can raise a claim, and if they show good cause under this multi-factor balancing test, Alhambra is a California case that applies to basically all cases. The petitioner is entitled to discovery. If they make a prima facie showing, they are entitled to a hearing to prove their claim, and then preponderance of the evidence. If they meet that standard, they get a remedy specific to the violation. And the remedies are a little bit complicated, but it kind of depends on when you bring the claim. So if you've already been sentenced, then you would either get a new trial or just get your sentence reduced. So focusing on sentencing and the pattern of disparity claims, there are 2 showings that an individual needs to make. The first showing is that they got a longer or more severe sentence than other similarly situated individuals convicted of the same offense. And then second, there's like a more systemic showing, which is that longer or more severe sentences are more frequently imposed on people who share defendant's race than on people of other races. And there's also a provision that accounts for the race of the victim, so you can also, like similar to Warren McCleskey, you can make that type of claim too, but I decided to focus on race of the defendant here. And the standard is that the totality of the evidence demonstrates a significant difference in sentences, and the prosecution cannot establish race-neutral reasons for the disparity. So one intervention I wanted to make is that I noticed in the case law there was a lot of confusion about what type of evidence can be offered, and this is a quote from a 2024 opinion discussing that it's not clear from the plain language of the statute or the legislative history what type of evidence is relevant. And this is from the statute. So the statute itself says that the evidence may include statistical evidence, aggregate data, or non-statistical evidence. And in evaluating the totality of the evidence, the court shall consider whether systemic and institutional racial bias, racial profiling, and historical patterns of racially biased policing and prosecution may have contributed to or caused differences observed in the data or impacted the availability of data overall. Okay, so that's a bit of a mouthful, but what I have noticed is that for a lot of the pattern of disparity claims, there's really just this sole focus on statistical evidence, but a lot of the literature and the court cases are ignoring these other categories of evidence. So I argue that pattern of disparity claims shouldn't be equated with the statistical claims, and litigants and courts should give significant weight to the non-statistical evidence as well. The statute asks us to look to the totality of the evidence, so we should take them at their word and look at the other categories of evidence that litigants can present as well. And part of the reason why I'm arguing this is because it has been very difficult for litigants to find data to present. The left are some types of data sources where you can get data to make an RJA claim. There are Public Records Act requests. There's also records from the California DOJ and the Department of Corrections. There's an asterisk next to the Department of Corrections because I know the 3 Strikes Project has brought some litigation under the statute, but they got a lot of data because of involvement with California Penal Code Revision Committee, so that's kind of like a specific situation, but usually California Public Records Act and DOJ requests. But some challenges are they're often very small sample sizes, and there are also a lot of privacy restrictions on this data, specifically a lot of the times intended to help people who are incarcerated, and the DA's office has kind of used that as a justification for not giving the data in order to make this claim. Also, as I mentioned before, the lowest standard on the statute is the discovery standard, but there's this like multi-factor balancing test that litigants have been grappling with, and that applies across the board, and it kind of, I mean, to me it seems very incompatible with this purpose of the statute to make this data available to people and allow them to bring claims. So those are some hurdles. And this is actually a QR code. It's not very mobile friendly, but it's called the RJA Paper Prisons tool. And the scholars that I mentioned earlier, they've gathered a lot of the data, mostly from the California DOJ, and then you can look at different arrests for different offenses and see kind of the racial disparities there. So it's an interesting tool. And now to talk about what do I mean by non-statistical evidence. So I'm going to take us back to just to give a little more context about what non-statistical evidence could look like. I had the opportunity before law school to work on this case under the North Carolina RJA, and ended up getting we ended up getting our client's death sentence overturned. And one of the categories of evidence was historical evidence. So we had a historical expert. This is a piece of evidence she presented. It was a billboard welcoming people to the county in which our client was sentenced to Klan country, also advertises a Klan rally, and there are a lot of historical records of permits being granted to the Klan to parade down the street where the courthouse was, and this is in Smithfield County where he was sentenced. Also testified a lot about historical evidence of racial violence against Black people in the county, and just the history of race relations, the lack of Black elected officials, all of that came in. There was psychological research about implicit bias on decision-making and prosecutorial affidavits and also court transcripts. So there really is a wealth of evidence that could be produced under this non-statistical evidence if we construe it broadly. And there are also opportunities to use statistical and non-statistical evidence together. So, for example, this is a prosecutor in the same case that I was talking about, and you can see that the race of the defendant is the second column. And in cases where there's a Black defendant, the percentage of Black VM is veneer members, so the percentage of Black veneer members who were struck. And there is a disparity there. There is definitely a greater percentage of Black veneer members struck in those cases with Black defendants. And there are also instances of the prosecutor saying very racist things towards Black defendants, such as calling them predators of the African plain and also calling Black defendants a piece of trash, even though he didn't use that language for other defendants. So there are times, especially when the sample size is small because of the challenges in obtaining data, like I discussed earlier, where non-statistical evidence could also be brought in. So another intervention I wanted to make was that no published decision has yet discussed the meaning of significant difference. This is a quote from a law review article, and I wanted to discuss what that could possibly mean. And the California RJA specifically says you don't need statistical significance in order to establish significant difference. And there are three kind of terms that get muddled in a lot of the literature and case law that I wanted to tease out. And causation and significance under the statute and statistical significance, they're related, but they're not equivalent. So the statute itself says that you don't need statistical significance in order to prove an RJA violation. And significance under the RJA is something that we ask courts to do all the time. We ask them to say oh, this had a significant effect on something else. And the statute gives courts the discretion to make that decision without needing to rely solely on statistical evidence. And that the other prong of this is that causation is sufficient but not necessary to prove a California RJA violation. So what I'm saying when I talk about causation is that there are methods you can use to show that race caused people to have higher sentences, and that is possible through if you have enough data, if you have a large enough sample size, but that should not be required in order to make a claim that you experienced a violation under the statute. Again, this is an example of how causal inference was used in the North Carolina case, they showed that race was a causal factor in the prosecution's exercise of peremptory strikes. So depending on the race of the juror, there was a strong causal relationship between the race of the juror and the exercise of peremptory strikes. Similarly, race can be used, causal inference can be used to show that race was a causal factor in the imposition of, for example, a life sentence under the 3 strikes law, or since California has a triad of sentences, maybe if litigants can show that Black defendants, for example, race caused them to be sentenced on the high end of the sentencing triad. So there are a lot of opportunities there. And I'll just mention briefly the Stanford 3 Strikes Project, which has filed recently 18 petitions on behalf of people in 8 different counties filed RJA claims, and they're using a new statistical method. I mean, not new to the field of statistics, but something different from what I was talking about, which is just comparing the mean sentences of 2 groups convicted of the same offense and seeing if there are disparities there. So there are a lot of opportunities aside from causation in order that you can use to prove claims. So I will leave us with a quote from the 2025 RJA amendments, which says, because racial bias in the criminal legal system is the result of centuries of historical and embedded racial injustice, it requires bold, concerted, and ongoing efforts to undo. This is a quote from Justice Jackson, actually, from the SFFA case, but she says, the only way out of this morass for all of us is to stare at racial disparity unblinkingly and then do what evidence and experts tell us is required to level the playing field and march forward together, collectively striving to achieve true equality for all Americans. Thus is the aim of California's Racial Justice Act and the legislature's intent in passing it. Its provisions should be interpreted in this light. So I hope that my research provided more information about how we can put this into practice to challenge racial bias in the criminal legal system. And thank you all for listening. Oh, right.
Q&A for Dayle.
Question.
First off, this was amazing. I knew about the RJA, but this really laid down a legal foundation and then what needs to be met. So it was very organized. I really enjoyed it. My question is, how would these claims for the RJA handle certain cases, like gangs cases, where like in certain areas, like certain races organize themselves into certain gangs, like certain. Yeah, so like certain gangs might identify with certain races, is what I'm trying to say. So in that situation, race would be a factor. It shouldn't be the sole factor, but it would be a factor. And then also, I'm not sure, maybe there is statistical evidence out there that say somebody of a certain race involved in a gang case is charged or sentenced harsher than somebody of a different race. I don't know, but what do we do in a case where maybe the statistical evidence is lacking, and even like historical evidence?
Yeah, this question has honestly kept me up. I've thought about it a lot because I know that that is an issue in gangs. There have been a few gangs cases under this statute where they've kind of like dismissed gang enhancements because of findings of racial disparities, but I don't know the exact answer to the question about like if they're organized based on, I don't know if you, like based on your research, have come across this as well, but it's a really good question, but I don't have a great answer to it. That's, yeah.
I also have a question, but I also want to start with the fact that this is such an amazing presentation and a great introduction into an area of law that I actually know a lot about. I think with Brionna starting with a discussion about the immigration crisis that's going on, I wonder if you think that there's any nexus that either exists or is being recognized by courts between RJA laws and immigration deportation cases. Especially since I think in one of the statutes that you were showing us, there was language that included the word national origin. And I would love to hear your thoughts.
Yeah, I think the national origin language is actually like makes room for people to make those types of arguments, and I have seen cases where there are like immigrants who are criminal defendants and like make that claim. I think there's definitely a nexus there. Yeah, I think the broad language that you pointed out, I think exactly allows for that. I think that's a really good point. But yeah, that's something I haven't like looked specifically into, but I'm sure, I know that people who have, like, are from an immigrant background, and there's been like comments about people who, like the way they speak or things like that have been considered like racial animus or bias under the statute. And I think the statute definitely allows for that.
Well, would that be if they were in criminal proceedings or just in their deportation immigration?
I feel like maybe both. I think in the first instance of just regular criminal court cases, maybe the RJA type laws could be implemented in the way that they traditionally have been. But I wonder almost if deportation can be seen as a type of sentence, in which case the interpretation of the law could be affected.
Interesting. Yeah.
but I just learned about this today.
I'm thinking about what we talked about in like immigration, like deportation is not a punishment. So I feel like that, but that's also a federal constitutional thing. So I don't know how California courts have interpreted that.
I just think like it would be it's really interesting
Yeah.
to think about, but it'd be a long way because just the way that the immigration law is functioning, I don't think deportation is seen as a punishment.
Yeah.
I just think the whole systems are so divorced from each other. Like even right now, they're just removing and firing long-time immigration residents and replacing them with what they call like deportation charges. So it's like, yeah, it'd be interesting to think about that. Oh, there are a lot of interesting arguments. Like now, people are doing a lot of, for people who are detained, a lot of habeas petitions. And we just see one of them yesterday. It's our first one, and it was great. But it's like those types of things are happening a lot in different stages of the deportation proceeding. At the point where people are just being detained.
I wanted to, before we close out, to give Dayle and Brionna just a chance to talk a bit about your experience in the fellowship. You can go to the next slide, Dayle. We are hiring for next year, so if you're interested and you're going to be into ORGL next year, applications are due on May 8th. Can both of you just talk a bit about, what's been like a highlight of your experience and, what type of student would you recommend being a frequent fellow?
Yeah. A highlight. We've done a lot of work. We've like worked on blog posts, tracking like laws throughout the country that have restricted what teachers can teach based on race and identity. I also like wrote a blog post about the Voting Rights Act, and it's just like in light of yesterday's decision, very timely. And I think it's been a really great experience to both work on academic research and then also talk with the attorneys at Wilson Sonsini. So just like that type of student who's interested in research writing, working on racial justice issues, it's been really great just to like this work on issues that kind of brought me to law school and then be able to do that in the law school context and like continue a lot of, also like I talked about some of my experience before law school and like picking up on that and applying what I've learned in law school to those issues. So that's been definitely a highlight.
Yeah, I think just echoing that.
Okay.
Echoing that. No, I think the highlight has been being able to work on these issues that like we care about so much, but I think more than that with people, like surrounded by people who care about it just as much and who are like so like just encouraging and so intelligent. I think like the team here at Stanford, obviously, but I think Wilson Sonsini has been just like incredible. I think the fact that we got to meet Harry Bremond was just something we like is very special to us to be a part of continuing his legacy and I think that I think just we're just surrounded by people who are just so great, and I think being around people who are great make us better, and that's been an amazing part of the fellowship.
We both have been fantastic, and everybody applied.
If you have any more questions,